Hello, everyone. We're just going to give it a couple minutes for everyone to join, and then we'll go ahead and get started. Okay, it looks like we have quite a few people joining, so I'll go ahead and get started. Hello, everyone, and welcome to today's webinar, Getting Ahead of California's SB 1162 Pay Data Reporting Law, hosted by Trusaic. My name is Pauline. I'm going to be your moderator today, but before we get started, I wanted to cover a few housekeeping items. If you have any questions during the presentation, please type them into the Q&A box in your Zoom control panel. We're going to address as many of the questions as possible at the end of the presentation. And for any questions that we don't get to, we will respond via email. And lastly, a copy of the presentation and the recording will be available to all attendees after the webinar. So keep an eye out for that email as well. And now, without further ado, I'm pleased to introduce you to today's speaker, Joanna Kim Brunetti. Joanna is our EVP of Regulatory Affairs and Chief Legal Officer at Trusaic. She is a former partner with Gump, Strass, Hauer & Feld and has over 20 years of experience advising clients on a wide range of employment tax and other business-related issues. She holds a Bachelor's of Science in Chemical Engineering from UC Berkeley and a JD from Loyola Law School. And with that, I will turn it over to Joanna to kick off the webinar.
Thank you, Pauline, and thank you all for attending today's webinar. SB 1162 has huge implications from pay data reporting, so I'm very happy to have you join me. So we'll be talking about getting ahead of it, which is going into effect in January, assuming it gets signed very soon, which is very likely, and I'll get into those details later. We're going to drill down to what exactly this means for employers and how SB 1162 is changing SB 973. As you may know, SB 973 went into effect last year in January, and the first reporting was due last spring. So it's not like employers have already gotten their sea legs on 973. And on top of that, now 1162 is going to further change it and add additional obligations to employers. So, California, from a big picture, California has always been a leader when it comes to employee rights. And conversely, California's always been a state and where there are a lot of employer obligations. And this is just another example. From an employee standpoint, California leads the way in fair pay. I mean, it's the first state that actually imposed pay data reporting via SB 973. And now with the addition of 1162, it's going to require separate pay data reporting for what's called labor contractors. In the most simplistic form, that would be like temp workers that you might have that aren't technically your employees, but they are contracted through like a temp agency or whatever. And those people, for those folks, there's going to be a separate pay data reporting requirement. So if you've got, the employee thresholds for both, you will have two different reports to submit. California is also kind of the first state to impose this obligation of, as part of the pay data reporting, not like just the sort of, the EEO1 style reporting that was in effect, and I can get into that in a little bit. But it's not just the pay or total pay or average pay, but now you're going to basically engage in a statistical analysis to identify what the mean pay is and what the median pay is, and that also needs to be reported. Overall, SB 1162 was intended to strengthen 973, and conversely, for employers, it will add additional obligations. And relatedly, SB 1162 also strengthens pay transparency. And what that means is it's going to make a mandatory requirement of pay scale disclosures to job applicants and employees. And we'll get into that as well. So there's a lot of things we're going to be covering. And I want to also kind of take a step back, like, why is this happening? What's driving this change? Well, put simply, it's the public sentiment. There is this overall public sentiment of wanting to promote pay equity, pay transparency. Pay reporting is a vehicle for that. And where's this movement? Where's the public sentiment coming from? I'm sure you've all heard of movements like Me Too, Time's Up, Black Lives Matter, and it really became highlighted from COVID because of the uneven impact that it had on females and minorities. And so it's really kind of highlighted pay inequity overall in the public view. Also, we have a tight labor market, and I'm sure you've all heard of the Great Resignation. There is significant competition for talent, and the employee reflects this sort of public sentiment. So that's what's going on. There's this really increasing push for pay equity, and this is California. One of the answers that California has provided in response to this movement. Okay, so let's go to the next slide. Okay, what is the purpose of pay data reporting? Well, so, I kind of highlighted that sort of pay equity. It's to promote pay equity. How's it going to do that? Well, pay data reporting actually reveals and gives you the opportunity to remediate pay inequity. So where you're submitting this pay data reporting to this California agency, and the idea is what it's going to show underlying that data is whether or not there is gender and or race ethnicity discrimination. And so the idea is if you can't fix what you don't see, and pay data reporting is basically forcing employers to look if they aren't already looking. And so what that does is by revealing what the pay data shows, you will have the ability to remediate pay discrimination, basically create more equitable pay practices, in theory, to not have pay discrimination from the get-go. And just overall, because you're submitting this data to a government agency, while that in of itself is confidential, well, now you're putting that data out there. And so it's going to encourage pay transparency of that data, or some version of that data, a more general form, for example, to your employees, perhaps the public. And the effect also is, this gives you an opportunity to demonstrate authenticity to whether it's your investors, your workforce, the public. It also is an opportunity for you to boost your company brand. So, let me just give you kind of an idea of what this is all about. According to Inc. magazine, 2022 is the year of pay transparency. And that concept of pay transparency is, intimately entangled to the concept of pay equity. So, what you're seeing is kind of this sort of, massive legislation in certain states that's relating to pay transparency, salary history bands, pay data reporting. California is the first to do the pay data reporting, not the last. Illinois just, came out with it a year ago. Theirs doesn't go into effect for another year, but that's kind of, we're seeing the beginning of that. And certainly from a pay transparency standpoint, we've seen a lot of that over just the last few years. Okay, next slide. Okay, so where is the status of SB 1162? It passed the state Senate and Assembly floors in late August. This is, last month. And it is cleared basically all California state legislative hurdles. California's governor has until September 30th to sign the law or veto, and all the signs indicate that he's going to sign it. And so assuming he does, which is extremely likely, so we'll know in about 10 days, it will take effect in January 1, 2023. So that's only a few months ago. There are some other changes with regard to the timing of it in terms of when the reporting is, and I'll get into that in a minute. But when you combine SB 973, 1162, it's potentially the most aggressive pay equity law in the US. It is akin to Illinois' SB 1480, which is less formidable from a pay data reporting requirement, but that SB 1480 also requires certification of actual pay equity compliance with federal and state laws. So in some respects, Illinois is more aggressive, in other respects, California is, but we're just kind of seeing what's going on. And, there's some question as to whether or not California is now going to add in this certification requirement. That may be coming down the pike. Okay. Next slide. So let's look at the key components of 1162. So what it does is it amends 973 to require employers with 100 or more employees to, as I had already alluded to, report the mean and median data for combinations of gender, race, ethnicity. It also, as I mentioned before, it requires you to submit some separate pay data reports for labor contractors and, for example, workers through staffing agencies. And it removes the option to submit the EEO-1 report in lieu of pay data report. Let me just take a step back regarding that EEO-1 report. As you may recall, like employers under SB 973, employers with 100 or more employees were required to submit this pay data reporting to the EEOC, but it only went on for 2017 and 2018. There's a lot of sort of litigation wrangling that went from sort of the Obama administration to the Trump administration. So the net result of all of that is it only went into effect 2017 and 2018. And what happened was states like California kind of filled the void of what was going on with the EEO-1. So they basically took over the EEO-1 component 2 reporting in effect for the state. And I think there were some employers that were kind of relieved that the component 2 EEOC reporting, was basically halted. But, California, states like California and Illinois, they, stepped up and filled the void. And now it got complicated because now the rules for each state dealing with this component 2 reporting gets complicated because they're not all the same. There's slightly different rules in terms of what to submit, when to submit. And now you got to pay attention to the state level instead of one uniform federal. And additionally, California state pay data reporting adds additional bells and whistles. So it's actually more complicated than the component 2 reporting. So what happened was SB 973 had initially allowed you to basically submit the EEO-1 equivalent. And now they want their own reporting. And so now you can't just kind of rely on that older style reporting. There's a removal requirement for employees with multiple establishments to submit a consolidated report, which was required under the EEO-1 component 2 reporting. That's not required under California. So California has its own reporting requirements. It still has the same job classifications, and sort of pay band information akin to the EEO-1 component 2 reporting, but it also adds this you have to identify for race, gender, and also this non-binary category in terms of gender. So it's male, female, and non-binary. Adds that complication. You're submitting pay data for these different job classifications, based on race, gender, ethnicity. So that what it does is SB 973 is slightly more complicated reporting than EEO-1 component 2 reporting. And then 1162 adds to that by adding in these sort of separate pay data reporting requirements for labor contractors and also adding in the mean and median pay data. Relatedly, 1162, I had alluded to earlier regarding the pay transparency, requires employers with 15 or more employees to disclose pay scale for both direct or through third-party job postings. And as you may know, under the old law, which I'll get into, it's the Labor Code 432. I'll give you the specific code in a minute. But what it does is now, before, the law was if the job applicant had requested it and conducted an initial interview, you would have to disclose it. That's not the case anymore. Now you have to affirmatively post the pay scale, whether you're posting it yourself or you're using a third party to post it. It also has an explicit requirement for employers to maintain the records of job title and wage history for each employee. So it has this documentation requirement that was not explicit before. One note is all of this was kind of organized through, and enforced by the Department of Fair, Employment and Housing, or the DFEH. but they basically changed their name to California Civil Rights Department, or CRD, and that became effective as of July 1. And this change in name really kind of speaks to the agency's emphasis on preventing discrimination and enforcing compliance. So there's some, speculation that it's going to be stricter. Next slide. Okay, so, with regard to 1162, the pay transparency component, as I mentioned, it's all employers that with 15 or more employees that have to disclose pay range in all job postings. Now, what's still in effect, 1162 doesn't change, is if you have at least one employee, you're still going to have to disclose pay ranges for a job applicant who completes an initial interview and makes the request. So that law remains the same, but it adds to it this additional job posting requirement for employers with 15 or more employees. And also, if you are working with a staffing agency, 1162 will require you to disclose pay ranges, in all job postings. And the one where you have at least one employee and you have to disclose a pay range to a job applicant after interview and request, that's under California Labor Code 432.3. That went into effect a few years ago, and now what this is doing is adding an additional layer of requirement. Okay, next slide. Okay, so what exactly do the records, what are the records that are going to be required? So under 1162, as I mentioned, you're going to have to track your job title and wage history rate for each position. You have to maintain these records for the duration of that employee's employment and at least 3 years after that employee leaves the company. So it's not 3 years, it's the time that person is there plus 3 years afterward. And these records need to be open for inspection by the labor commissioner. And the failure to do so, it creates this rebuttable assumption that it wasn't good information, that you didn't keep track of. So you're going to want those records to kind of prove that you provided these disclosures. Okay, next slide. So what's the timetable? As I mentioned, this is anticipated to be signed in about 10 days or less. And so that goes in, and assuming it gets signed, it will go into effect January 1, 2023. And one of the things that SB 1162 did was change the sort of time frame of the SB 973 reporting. Before it was March of each year that you had to submit it. Now it's May 10th. So this is the deadline for 2022 annual mean and pay data reports to the CRD. That is due on May 10th, 2023. And then going forward, it'll be an annual deadline of May 10 of the following year. Next slide. Okay, so, I want to talk about how the pay data report is going to be used. And earlier I had talked about how the purpose of this is to sort of reveal if there are pay inequity issues and give you an opportunity to remediate. So the pay data reporting that you're submitting, what it is still raw data. It doesn't consider things like wage influencing factors like tenure, seniority, qualifications, merit, like things that tend to go into why Susie gets paid more than John, or conversely, why John gets paid more than Susie. Like on an individual basis, there are going to be considerations on sort of merit or seniority type considerations as to why a sort of apparent pay gap exists. But in reality, that what seems like a huge pay gap might not even be a pay gap. Like it may be that these factors, these legitimate factors, are totally justify why there is a pay gap. But when you're submitting the pay data, you're not putting in any of those factors. You're just putting in the raw data. What you're putting in is that John is getting paid more than Susie. That's all they know. And so, it's looking at it from a gender standpoint and a race ethnicity standpoint. So all they know, like, for example, is that men get paid more than women in a particular job position. It could be that the men, in fact, have more degrees that are pertinent to the job than women in that position. But you're not, the data doesn't consider that. You're just looking at the raw pay data. And so that is an issue. So this agency, they're going to receive the pay data, they're going to look at it, and they're going to go, hey, let's see, wow, this particular company has huge wage gaps from a gender standpoint, for example. And so, you're opening yourself up to be a target for these kind of investigations. If you haven't actually gone back and done a pay equity analysis to see, well, when you consider seniority, merit, et cetera, in fact, there is no pay gap, or maybe the pay gap is the actual pay disparity. When you account for these sort of legitimate factors is actually very small. You won't know that until you actually conduct a pay equity audit. But meanwhile, you've submitted this perhaps not good looking picture of your company's pay pay, because all you've done is submitted the raw data. So it's really important to understand that you need to do a pay equity audit, ideally before you submit the pay data report, so you know what exactly you're submitting. And so you can know sort of defensively that pay data, it is what it is, but in fact, there's no pay inequity. Or if there is pay inequity, you're actually addressing it. And mind you, so today's presentation is about getting ahead of it. That data is going to be submitted year after year. Do you want to just wait until you get an investigation from the CRD, or have a former disgruntled plaintiff subpoena those records? I mean, they are theoretically confidential, but that doesn't mean they can't get them by subpoena. They could subpoena you. They can theoretically subpoena the agency, and now you're in this sort of defensive posture where you're trying to deal with a pay discrimination lawsuit. There's it was in the news not too long ago. Riot Games paid like $100 million in connection with their pay data that showed pay inequity. And if they could have shown that there wasn't pay inequity in connection with the pay equity audit, I would surmise they wouldn't have been in that position in the first place. But that's kind of the sort of reverberation of pay discrimination. So we don't want to be at the responding end of that. We want to get ahead of that, and any agency investigation. Okay, so when what the California Department of Civil Rights, what they're going to do is they're going to use that data to identify pay discrimination, analyze it to identify unusual wage patterns. It'll also identify who they want to prioritize for pursuing in terms of enforcement. And for them, it will more effectively allow them to prosecute which employers with pay inequity practices. So the idea is, if you want to get ahead, you want to do a pay equity audit to see where you stand, because you can't fix what you don't see. Okay, next slide. So, okay, so let's say you choose not to submit the report. There are huge penalties, and that's another layer that 1162 adds to 973. 973 didn't specifically talk about penalties. It really kind of focused on, if you don't comply, the agency can force you to comply. Well, I mean, you had to comply in the first place, so perhaps that didn't have as much teeth. And so what this new layer is adding is, this is SB 1162 is adding in now penalties for not reporting. So, the first round of penalties is $100 per person, per employee. And so if you don't submit your report and you have 100 employees, and my math skills are super challenged, so that's $10,000. And if you have repeated violations, you have a second violation, it's $200. So if you have 100 employees, you don't report a second time, that's $20,000. Well, if you got 5,000 employees, now we're looking at a range of $500,000 to $1 million in penalties. And that doesn't mean you don't have to submit the report. It means you're going to get penalized for not submitting it, and you still got to submit it. So it is not a good idea not to submit this report. These penalties put some real teeth into California pay data reporting. Okay, next slide. Now, I want to talk to you guys about this interim amendment that ultimately got eliminated, and why? Because this might be a signal of things to come in the future. There was this interim amendment to 1162 where they were going to amend it to require the agency to publish employer pay data reporting. And while that's not as common here, on this side of the pond, if you will, in the EU, there's for example, UK actually has these shaming laws where organizations, I think 250 or more employees, they have to post the wage gaps on their website. France has a similar kind of requirement. I think there's certain indexes that they have to disclose. And, where the US will often look to the EU for what they're doing, and then sometimes they will use that, as a foundation for their own laws. So this requirement to publish employer pay data is not unlike what we see in the EU. So this might come again. There was an amendment, there was an AB, I forget the specific legislation name, but a couple of years back that really mirrored the UK model. And like this particular time it got eliminated. Apparently, there was a lot of support, but the California Chamber of Commerce labeled this bill a job killer and raising concerns that it would just, facilitate more lawsuits. But this previous language in 1162, where employers would be required to publish pay data, that made it through several amendments, and the last one, before the one that is right now, subject to signature, it didn't make it. But you know what? It could come up again next year, and sort of the arguments of, oh, it's only going to facilitate more lawsuits have just increasingly become less effective in terms of getting law passed. So what you'll probably see is you will see this come up again. But it's notable that it was in the bill. It got eliminated, but that doesn't mean it's not going to be reincarnated in some form later. Okay, let me go to the next slide. Now, kind of going back to what is in the language of SB 1162, 1162 can affect employers anywhere in the US. Basically, it used to be that it was employers with at least 100 employees and who submitted an EEO-1, who are subject to EEO-1 filings. That was the requirement. Now it doesn't matter whether you're subject to EEO-1 filings or not. It's just basically 100 employees. And it's important to note what the 100 employees means. If you have even only one employee in California, but otherwise you have 100 employees, you're going to have to comply. So that's why that's kind of important, and it has this sort of extraterritorial impact of 1162/SB 973. It's important. So if you are a California employer, and let's say you have 50 employees in California and 51 employees outside of California, you're subject to this law. You're really only reporting on the California employees, but you're subject to reporting is the bottom line. This isn't new. I mean, like Colorado has a similar kind of extraterritorial reach of their law. Colorado requires certain pay disclosures, even if one employee is working in Colorado, to trigger that Colorado pay equity law. So, here in California, if you have at least one employee in California, and mind you, that includes remote workers. So, in this sort of, I can't really say it's post-COVID because we're still in it kind of. But since COVID, remote workers are, it's a very real thing for most organizations. And so, you can't ignore that. You're going to have to pay attention to where your remote worker is, where they're assigned. These are going to be relevant to figuring out whether or not you have to submit pay data reporting or not. Okay, let's go to the next slide. Okay, so I give you this map because, as I mentioned, Inc. calls 2022 the year of pay transparency. You know, until maybe like in the last 5-6 years, there's just been this increasing number of states and local, cities where they're all coming up with similar sort of pay equity laws. So, from a pay transparency one that California is now really beefed up through 1162, other states like Colorado, Connecticut, Maryland, Nevada, Rhode Island, Washington, Colorado, sorry, said Colorado twice in there. Okay. But those states all have pay transparency laws similar to the one in California. They all have their little kind of nuances that are slightly different, but that's the gist of it. Mandatory pay range disclosures in all of those states. Some of them also, the nuances will include things like promotions, applies to sort of internal positions and not just external positions, things of that nature. There's also New York City, 2 cities in Ohio. There's others, but this is just to kind of give you a sense of and these all are been happening very recently over the last few years. Now, Massachusetts and New York, there's bills in the works that are probably going to take effect and then not, get enacted and, come into effect in the not too distant future. I alluded to Illinois, that also requires pay data reporting. And there's also this equal pay registration certificate requirement, basically certifying that your company, your organization is complying with equal pay on a federal level and on a state level. And I believe that is the only state that does that right now. Is it the first one? Maybe the other states will follow. So it's important to kind of pay attention to what's going on in other states and also in other, outside of the US, because a lot of times that gives you a hint of what might be coming in the future. The legislators, they look at what's going on elsewhere and they, consider whether or not that is something that they want to do. My last count on salary history bans, which is also obviously related to pay equity, is right now, it's in 21 states and DC, and there's a bunch of different local bans. And, salary history in a nutshell is basically, you can't ask what a job applicant was getting paid in their prior position to figure out what you want to pay that person in the position that that person is applying for. So, there's nuances depending on the jurisdiction, like, if they voluntarily disclose it, that's one thing. But generally speaking, you can't rely on a person's prior salary to figure out what that person's pay should be in the position they're, applying for. And, the theory is, well, if there was pay discrimination in the prior job, all you're doing is kind of propagating that discrimination because that person's using that and to a disadvantage for their new position and so on. So that's just another way of kind of addressing pay equity. So if you want to promote pay equity, which is this, that people are paid equally, irrespective of race, gender, every different protective class. In that concept, pay data reporting, pay transparency, salary history bans, pay equity auditing, all of that is geared towards pay equity. And they're all kind of coming at it as slightly different nuances. There are a number of states that, for example, allow employers to basically have a safe harbor from pay discrimination if they conduct a pay equity audit. And some of those states, like Massachusetts, for example, if you conduct a pay equity audit, you don't actually have to achieve pay equity. It just has to show reasonable progress. And there's some kind of time frame where you can use that, affirmative defense, so on. But these are all tools in the pay equity tool chest of trying to achieve pay equity. And we just see more and more states, engaging in that. And so it's a value to pay attention to. This SB 973/1162 reporting is another tool. But all, for the same purpose. Okay, next slide. And, kind of echoing the idea, pay attention of what else is going on in other jurisdictions. Well, obviously federal applies to all California employers, in addition to California laws, but it's also good to pay attention to what's going on the federal level. I had mentioned earlier about that component 2 reporting. So basically what happened was component 2, that pay data reporting, a simpler version than what's going on under 973/1162. That reporting was introduced under the Obama administration, and then it was halted under the Trump administration. And so, as I mentioned, it only took place for 2017 and 2018. And that's when, after it got halted, some states sort of swooped in to try to fill the void and made it more complicated. And you sort of created this patchwork of law. So there is, basically component 2 is likely to come back, at least according to EEOC Commissioner Keith Sunderling. So I ask myself, well, does that mean that if the pay data component 2 pay data reporting is coming back, does that mean that the California state data reporting is going to go away? And at least what I've seen in other contexts, probably not. Now you're going to have to do component 2 reporting, and you're going to have to do California state reporting. Great. Well, that's what I anticipate will happen. So, also you have to understand kind of where the feds, their kind of view of things are. The Biden administration kind of introduced this national strategy for achieving gender equality. OFCC directive makes clear requirements for contractors to conduct pay equity. There was this new study on EEOC pay data report collection, finding that pay data is key to prevent pay discrimination. So this is kind of the federal zeitgeist of where pay equity is. And so there is a likely, and it makes sense that the OC commissioner would say that pay data reporting is coming back. We'll see if there's going to be other things as well. But that the federal government, the EEOC, Title VII, and the Equal Pay Act, those have been in the books, over 60 years. So in theory, we ought not have pay discrimination, but that hasn't, 60 plus years later, it's still around. And, kind of the reverberation of that was the sort of component 2 reporting, recognizing that not enough is being done. Under the current administration, more is likely down the pike. We just see what that is. And so it's good to pay attention to what's going on, particularly in the EU, also Canada, Australia, and also, what's going on at a state level, because legislators look to other legislatures to get ideas of how to, promote pay equity. Okay, next slide. Now, I had talked about pay equity, is sort of the value of pay equity in terms of, like affirmative defenses, for example, in Massachusetts. It's also defense, on a slightly different scale for Colorado, and I think it's Oregon as well. And there's, I think, another state. But anyway, so I'm trying to, just talk about being proactive in pay equity. Pay data reporting is probably the most, the most obvious example of why you want to conduct a pay equity audit. If you don't, you're just submitting this raw data, hiding your head in the sand, not knowing what it is you've submitted. So instead of waiting defensively for a subpoena or a lawsuit, why not go ahead and figure it out? Because now that data is submitted, so, and you don't have any explanation for it. Why don't you go find that explanation? And does your organization have pay equity or does it not? And if it doesn't, what are you going to do to remediate it? So that pay inequity is there, whether you know that it exists or not. Like, the data is there. Now, the question is whether or not you're going to look and figure that out. So, as I said, you could sort of take it from a defensive posture and do nothing and wait like a sitting duck, or you can be proactive and you could actually use that to not only make sure you don't have pay inequity, but also you can get ahead of that to promote your own brand. I mean, pay equity is a really important thing, increasingly with the younger generation, as part of why they choose an organization. So, you can use that pay equity audit to your advantage, not just for pay discrimination, but just PR purposes, promoting your brand, improving sort of your workforce view of you as an organization. So what does it mean to conduct a pay equity audit? Well, you are basically figuring out your, what is the expression? You can't manage what you don't measure, or what gets measured gets managed. Figuring out where you are, where your baseline is, figuring out where you want to be, and then figuring out whether you're actually making progress to reach it based on whatever tools, policies, practices that you implement to reach that goal. So doing a pay equity audit allows you to establish the metrics and a measurement system to track progress towards pay equity. It assesses and analyzes the compensation policies to actually ensure that you have pay equity. And once you've gotten the metrics, figured out your plan, it allows you the ability to sort of communicate sort of what your vision is, what kind of goals you want to set to those people who care, whether it's your employees, your investors, job applicants, public in general. And, basically, because workforces are fluid, what your snapshot at your first pay equity audit isn't necessarily what's happening months down the line. So kind of doing that on a continuous basis to see how much progress you've made. And that's all part of pay equity. So let's go to the next slide. I want to take a couple of minutes just to kind of talk about pay parity and just sort of pay equity software and why that's important. Because when you're doing a pay equity audit, you need to have kind of a robust statistical analysis to support it. And pay parity software, what that does is it analyzes all forms of compensation. So, you're not necessarily just looking at salary. You also may want to look at bonuses, commissions, other aspects of compensation. And then this way, with pay parity, you can actually pinpoint the pay disparity at the intersection of gender, race, ethnicity. So you could have a pay disparity for gender. You could have a different pay disparity for race, ethnicity. But when you intersect the two, there could be a compound effect, which has certainly been documented historically. And so, you want analysis that considers both simultaneously. The other things that pay parity will do is it will prevent wage compression. So, when you are looking at, and I'll talk to you about sort of what it is you offer. When you offer a position to someone and pay, assuming you've already done sort of the analytics to figure out what that person's pay is, like you often hear like people who stay at a company, they don't, their salaries don't go up the way salaries go up where with job skippers or job hunters, hop skippers. Basically people who are skipping from job to job, those people tend to make bigger salary increases. So one of the things that doing a pay equity audit does is really identifies what your range should be, for a position, so that you don't have the senior manager making slightly more than the new entrant because of the hot labor market. So this gives you that kind of visibility to understand where the wage ranges should be per position. And so conducting a pay equity and monitoring it allows you to also communicate whether you're making progress and know that that progress is sort of solid based on the data. And you can do it in a way under attorney-client privilege, under guidance of counsel. And it allows you to comply with pay equity laws like 1162 in terms of now you know what it is, what data you're submitting to California Department of Civil Rights, and to know that data even though it's the raw pay data, you know that underneath that raw pay data or supporting it is legitimate factors like seniority, tenure, merit, etc., that legitimately explain why that big pay gap is really not there, or de minimis. And you can do that, at least with our software, you can do it continuously, so that you know what's going on a ongoing basis. Next slide. Now, one of the things you want as part of your pay equity audit is you want to be able to not create more pay inequity when you are offering new salaries to new to an applicant who you're thinking about hiring. And then when you consider 1162 strengthening of employee rights, if you will, so that you now have to mandatorily disclose the ranges. Well, how are you going to figure out the range? Traditionally, usually it's like a manager saying, well, I think this person ought to get from this range to this range. It's probably like a subjective, the biases of the person type analysis, very ad hoc. Sometimes it'll be like they go do a little bit of research online to figure out what the market is offering for that position currently, and then they get approval. That's often the process. It's not data-based. While it's certainly intended to be objective, it is not in fact objective. And so part of this 1162 mandatory requirement to post job pay scale for job positions is you want to post a range that, one, is not going to adversely impact your sort of pay equity analytics that you just conducted, right? To make sure that you aren't basically creating more inequity, or basically creating inequity in the first place by now offering a position at a certain salary that doesn't reconcile with your pay equity analytics. So here's an example. So here's a software engineer manager in San Francisco, and you see kind of three different ranges. One, the bottom one, is perhaps internally what the organization pre-approves of, like the manager or this person's supervisor gets approval for this range. And then at least with our software, we actually rely upon Lightcast, which is which has millions of data inputs to give you reliable external benchmarks for what the salary ought to be, or what the salary is out there in the market. So it's really like having that kind of reliable external data is really important when you are figuring out what pay to offer. So, this is that external range. And so then when you take that and you reconcile it with your pay equity audit, what you see is the pay equity range, and it is notably smaller range than the other two. So this tells you, if you want to maintain pay equity, this is the range that you need to provide. And that's backed up by the statistical robustness of your pay equity analysis. And it's backed up by external benchmark data. This is that Lightcast labor market data that supports that range. So, it allows you to sort of confidently share pay scale in your job disclosures that you're posting essentially to the public. And you are preventing pay inequity from starting in the first place. And at least with our software, it provides you sort of real-time results, so you are minimizing risk. And it also elevates your brand with external and internal pay benchmarking. All right, let's go to next slide. And let's launch the poll question. Do you have a plan in place for meeting the requirements of 1162? Okay, let's go to the next slide. Okay, so we've got about 10 minutes left, and to the extent that we don't have time to finish all of the questions, um, we can provide you via email responses to to the questions. So there's like a bunch of questions. So I am certain we're not going to be able to go through them, but I'll go through them as much as I can. So one question says, you must submit pay scale. What if you don't have established pay scale? So I want to make sure I answer that question, the right question. So the way SB 1162 kind of modifies that labor code 432 something, I'm trying to remember what code it is, but you have to, this is if you haven't, if you have at least 15 employees, you have to disclose the pay range for all job postings. This modifies labor code 432.3. And so, pay scale, pay range, like the statute is very, it's standard. So if you don't have an established one, you need to establish one. One way to do that is through software such as Pay Parity, where you can conduct your pay equity analysis and using the sort of external labor market data, and that can help you, that will allow you to figure out what you want to offer. So if you don't have an established pay scale, this will give you a way to establish your own pay scale. Okay. Okay, so another question. This one's a quick one. I missed when this takes effect. Can you repeat? Yes, it takes effect January 1, 2023. That's like in 3 months, so very soon. Let's see. It says, for out-of-state employers, do we count all employees or those in California to determine the 15 plus requirement? Let me see if it's certainly for employers with 15 plus. I have to look more carefully at whether or not the 15 plus employees all have to be in California. So for that one, I will follow up directly. Okay, let's see. It says, how does 1162 reporting impact the group that I outsource under a PEO arrangement for payroll and workers' compensation services? So that kind of goes into that labor contractors question. And so if you have 100 or more workers through this labor contractor, you're going to have to submit a separate report for those workers. So the labor contractors have a very specific definition. It's basically workforce through a third-party organization that provides work to you. It's if it kind of depends on exactly what the arrangement you have with your PEO. But if those workers are considered labor contractors, where typical staffing agencies, for example, where they come on board and do all the work, they are your workers, but they are paid through another, a third party. That sort of classic example is what would fit in there. So whereas only for certain parts of the services, it'll get grayer. So I'm not sure if that group that you're talking about are providing work just to your company, that would be clear. So that it depends on exactly what services those workers are providing to you and what exactly the PEO arrangement entails. And I'd be happy to follow up with you to understand better what the question is, if you need more information. Okay, so I have another question here. It says, does 1162 apply to nonprofit organizations? Yes, it applies to all employees, employers, sorry. Let's see. There's a question that it says, if total employees inside and out is less than 100 employees, then doesn't apply. Correct. 1162 applies to, well, with regard to the pay data reporting. If you have less than 100 employees, you are going to be, you're not subject to the pay data reporting. However, there is, as I mentioned, 1162 has other, amends other law. That was that labor code for 432.3. And that's regarding like the 15 plus employees in terms of disclosing pay scale. So if you have less than 100 employees, but you have more than 15, you have that mandatory requirement for pay scale. And of course, the continuing requirement that if you have at least one employee, if the job applicant asks for wage history, if the job applicant asks for a pay scale and they conducted at least one interview, that would have to be disclosed. So the SB 1162 amendments to 973 wouldn't apply to employers with less than 100 employees overall, but even if you have less than 100 employees, you still be subject to 1162 with respect to the changes to Labor Code 432.3. Okay. Let's see. I have another question here. If you are posting a position with the location remote, while having one employee in California and assuming some applicants could come from California, do you have to post pay range? So I'm not sure that I fully understand that question, but let me answer this. If you are an employer with at least 15 employees, you have to, you have to disclose, the pay range. So if the position is remote, that's still, that it's not going to make a difference. Whether the position is remote or not, it's, if you are subject to the 432.432, for some reason, every time I try to spell it out, I can't seem to get the code right. 432.3. With regard to pay scale, whether or not the position is remote, you're still going to have to post the pay range. Okay, I think I have time for one more question. It says, can you share the deadlines? Yes, it's actually on the slides. And as Pauline had mentioned earlier, the deadlines are spelled out, but the next deadline is May 10, 2023, and then annually after that. And what it did was it, basically modified the prior deadline under SB 973 to May 10, from March of the, March to May 10. Okay, I think that's all the time we have, but I will answer all of the questions separately via email to the extent I didn't answer. And you're certainly free to follow up with me. If you go to the next slide, for the last slide, I'm sorry, one slide over that, before that, you'll see my contact information. Anyway, I very much appreciate your time and listening. And so back to you, Pauline.
Thank you, Joanna. So yeah, with that, like Joanna said, we will be emailing you a copy of the recording along with the slides. And for any other questions, we'll try and directly reach out to you guys. If not, again, feel free to reach out to Joanna by email. But thank you guys for attending and have a great rest of your day.
Thank you.